Hi, everybody. Welcome to Trial Alchemy, and I'm delighted today to have as my guest Brian Chase. Brian's the leader of an eight-attorney AV-rated national law firm up in Newport Beach, been in existence since 1977. Brian is the managing partner, and he's a senior trial attorney. And the firm specializes in automotive defect cases, catastrophic personal injury cases, mass torts, pharmaceutical and medical devices. And Brian's had leadership roles in those cases. Employment, consumer class actions, he's also had leadership roles there. Brian's been very involved in legal groups, and as part of the leadership, he was the 2015 president of the Consumer Attorneys of California. He was president in 2007 of the Orange County Trial Lawyers Association. Brian's a member of ABOTA. And in 2014 and 2004, he was named Trial Lawyer of the Year in Products Liability by the Orange County Trial Lawyers Association. He was also in 2012 named Trial Lawyer of the Year by the Consumer Attorneys of California. And that same year, he was nominee for Trial Lawyer of the Year by the Consumer Attorneys Association of LA. Brian's published two books. In 2009, he published a book, Still Safe at Any Speed, and he published a second book in 2019 called The Second Collision. So Brian has been the lead attorney in four important precedent-setting appellate cases, and those have dealt with issues like form nonconvenes, the consumer expectations test, non-retained expert testimony, and dealing with design immunity. So without any further ado, Brian, thanks so much for being a guest today. It's really a delight to have you here. And I know that people who listen to the podcast are going to learn a great deal from you. So thank you very much.
Well, Monty, thank you for having me on. It's a real honor to be here. I'm a big fan of yours, so I'm looking forward to this little dialogue we can have today. So thanks.
Well, great. So, Brian, to start off, would you tell us about one of your most satisfying trial victories?
Okay, that's an easy one. It's hard to say which case is your favorite, but the one I like to talk about is Romine versus Johnson Controls. And the reason that is so satisfying is twofold. One is we got a really nice, multiple eight-figure verdict. So that was great. I got my client compensated, which was able to take care of her for the rest of her life, ramp out her house, get her a van she could drive with her hands and things like that. So that in and of itself is very gratifying whenever we can do that for people. What makes that case extra special is it went up on appeal and we got a published opinion. And so it's the only published opinion affirmatively saying you can use the consumer expectation test to prove defect in a seatback case. It's the only one. And so now it's stare decisis. So the gratifying thing about that, obviously, is for as long as that's on the books, who knows how many dozens, hundreds, or thousands of lives won't be saved because cars are still going to be made defectively. But the attorneys trying those cases have a significantly better chance of prevailing with the law that I made in that case. So that's really gratifying.
Well, good work on that. That's excellent. And that's one of those things where sometimes the attorneys who appeal, which I'm sure the defense appealed it, may end up ruining the day that they file their appeal.
Yeah, no, good attorneys need to be smart on that.
Yeah.
I have lost trials and not appealed certain issues because I knew the law favored me, but I didn't want to get a bad opinion on that one issue. So, good trial lawyers need to be careful on what they want to appeal.
Yeah, I think you're right. And like every part of trial, you have to be very strategic. And you got to be strategic about, do you want to take an issue to the Court of Appeal that may create some bad law for whatever issue you had in your case?
Right. No, exactly.
Want to be very careful about that. So I know you've tried a lot of cases. You've had a lot of success in the courtroom. Now, when you're getting ready for trial, and some people may be spending a month, in the pre-trial final prep stage or longer, I kind of think of it as a necessary grind. We have to do the work. We have to get control and mastery of the case. We got to be ready when you hit the courtroom. Is there any kind of a approach you've developed over the years for how you get everything ready in that final stage, whether it's a month or however long it is?
Yeah, what I do is, and I think a lot of people maybe do this, but if they don't, what I do is I will figure out how much time I think I need to prepare heading into it. You know, it's going to be at least a couple of weeks, and sometimes it could be a month. I had a medical device trial, and that was going to be novel for me, so I stayed home preparing for that for about 6 or 8 weeks. But regardless of how much time, I just stay home and isolate myself and get away from the noise of the office and being an office manager and things like that, and just go through the case with a fine-tooth comb, summarize all the depositions, get it all memorized, look at all the exhibits, get that all together well in advance of trial, meet with the technician, start working on opening statement, even closing argument, direct exam PowerPoints, and just hunkering down, because as you say, it's a necessary grind. You can't wing that stuff.
No, you've got to be prepared. You've got to know where everything is and what you got to deal with once you start that trial, right?
Yeah, absolutely, absolutely.
But on the other hand, now let's talk about this. If you've done that homework and you've done all that work, like one of the things I've always worried about in getting ready for trials is, have I prepared enough? Am I fully prepared? But once the bell rings and you start that trial, you kind of get into the zone, don't you?
Yeah, yeah. I mean, one is I I never feel fully prepared. I mean, you always want another day of prep, or you always want another. I think we're all that way.
We're all that way.
And it does become, there's a point in time where it's just kind of paralysis of analysis. You just got to rock and roll. And as you just pointed out, Monty, if you have done that grind prep work ahead of time, even if you wish you had a little bit more time to prepare, once you start, you are in the zone. You're not thinking about, I wish I would have done this, I wish I had a little more time to do that. At that point in time, once you're in the zone, I know I feel like, man, I got this. I am so well prepared. Let's just go into it.
And
Yeah.
that's one of the things that could make it really fun. I mean, you're in the trial,
Yeah.
but you're in the zone and
Yeah.
you're doing your thing.
Yeah. I mean, trials are roller coasters, right? You've got the high days and the low days. And that's what makes it fun too. I mean, I guess you'd like every day to be good, and they're not. But yeah, when you're very well prepared and you really feel like you've outworked the other side or can on certain issues, it is just so gratifying when you got somebody or a certain witness that you're going to be able to attack and sway them over to your side.
Well, I think outwork the other side is key. I mean, one of the things that I've always felt, it sounds like you do too, is, somebody might be smarter than somebody else. You got different variations, but my goal is nobody's going to outwork me, and I'm sure that's what you do. You want to be fully prepared. Nobody's going to be out preparing you.
Oh, 100%. And I've been like that my whole life because I know my limitations. And, I'm not the sharpest tool in the shed. So it might take me 2 times or 3 times longer than somebody else to grasp a concept. But what I also know about me is once I have it grasped, nobody is going to be able to spin me on whatever story it is I have to tell. But I need that extra prep time. And yeah, no one's going to outwork me just like you, because you got to know where you're weak and where you're strong. And my weakness is I don't grasp concepts immediately, but I know if I put in enough time, I will grasp, and I'll grasp them better than the other side.
Yeah, that's key. And that's why you've had a lot of success in the courtroom. So, in terms of stories you may tell, one of the things that any good trial lawyer does, especially plaintiffs, but everybody does, is you have themes for your trial. You've got some kind of phrase or theme or way to describe it. So, what are some of the most effective themes you've had in your trials that you thought have worked really well?
Right. Yeah. So for me, and for the last 15, 20 years, almost all of my trials, maybe all of them have been auto defect trials. And so my theme is pretty consistent, but I've got a couple of variations on it. So one thing I do, and a lot of people do the do products cases, is you have the theme of profit over safety, because in all of these cases, you're going to be able to show that you could have saved a life, you could have had somebody not paralyzed and walked away, or sometimes as little as $5, sometimes for as much as $50. But so I've always got that profit over safety thing. And then another variation I do in addition to that is you can't talk about law in the opening statement, really, or in voir dire. So I talk about it. I just don't let the jury know I'm talking about it. So if I'm going to go risk benefit, I will start it right out of the gate. Hey, good morning, ladies and gentlemen. And then I'll have risks versus benefits up on a PowerPoint slide. And I'm not telling them that's what the law is, but I'm letting them know, hey, that's what this trial is about, ladies and gentlemen. It's about the risks versus the benefits of this roof or this tire or this whatever. And then my very next slide, for example, if it's a roof crush case, I'll have a car hung upside down, 1 foot off the ground, drop it, roof flattens like a pancake. Okay. Then on the assembly line for $40, I've got one modified. I drop it, it bounces like a ball and doesn't break the glass. So then I reiterate, it's about the risks versus the benefits, of that roof. So in my products cases, it's always going to be profit over safety interwoven in with the risk versus benefit, and talk about the law and just let them realize, okay, that's what I'm looking at in this case. What are the risks? Serious injury or death. What are the benefits? I save $5. And so that's really what I hammer in all of my products cases.
That's great. Now, in all your products cases and other cases you've tried, you've also seen themes from the other side, the defense. And what kinds of themes have you seen from the other side that you thought were pretty good themes?
Yeah, well, if I can't exclude it, and in California, I always have, except one time. In other states, they have different law than California. So, the theme that the defense wants to bring in is, hey, this vehicle complied with the Federal Motor Vehicle Safety Standards. Okay, and national polling has shown that at least 10 years ago, I don't know where it is now, but 2/3 of all jurors or prospective jurors think if a car passes the federal standards, it is kind of per se non-defective.
Mm.
So the themes in these cases, and if I don't exclude it, and if anybody listening has one of these trials come up, you're going to want my motions in limine because I keep this out more often than not. But they will come in with the theme of they comply with all the Federal Motor Vehicle Safety Standards. Aren't we great? And then if the judge allows them, they'll say, hey, look, our car ranks here on a bar graph going up and down. It's better than 75%. Our roof is stronger than 75% of the other roofs on the road from Chevy, Ford, Mercedes, whatever the case may be. And they like to compare that. And then, which is tough, and then the brutal one is, but there's ways around it. In the auto defect cases, it's always a big crash. Someone is rolled over at 60 or 70 miles an hour or rear-ended at 40, 50 or 60 miles an hour. It's never a fender bender.
Right.
So the other thing they do is they come in with statistics and they let the jury know, if the judge allows them, this crash is in the top 1% of all crashes in the world, and just play that hell of a wreck defense. So those are the three big things that, you've got to contend with sometimes.
And in your motions, have you had success in keeping all three out, or two of the three, or one of the three?
Yeah, yes. So on the comparisons to other vehicles, I've always been able to keep that out. If you dismiss your negligence claims, because it's not relevant for risk benefit, strict liability. So I keep that out. I have always been able to keep out the Federal Motor Vehicle Safety Standards. Now, somebody did an appeal a few years ago that has tweaked that a little bit, and I've still not lost the motion, but there'll be the right case where you will now. But I've always been able to exclude that stuff, and that just makes it great. The statistics, I've not been able to exclude. One time I got their expert stricken just because of foundation on the stats.
Right.
But that one normally comes in, and then we just have to argue around it that, well, it might be in the top 1%, but you don't need a safety device when you're in the parking lot. You don't need a safety device in your garage. You need an airbag or a seatbelt, when you're in that 1% crash, and you just kind of spin it the other way.
Yeah. Okay. That's great. So you're trying your cases and you've got all these parts of trial. What part of the jury trial, in your opinion, is the most important?
Man, the short answer is I don't think there's a consistent universal answer for that, certainly in my opinion. And, if you go by the people, the PhDs, the psychologists and psychiatrists that analyze this stuff, they say whatever, 90% of people make up their mind in the opening statement. I don't know. But knowing that people smarter than me have said that, you got to give it your go in the opening. But I don't know, but I feel like I have won a lot of cases in closing argument when you can just put it all together and just argue it and spin it your way. So I think it's all important. I think, the opening, because the people smarter than me say that's important. I'm a big believer in hammering and closing argument. And then, it's also, you've got to keep the jury entertained. So that I always want
Right.
a couple of witnesses. It's like a movie, and I used to be an actor back in the old days. And so I learned a lot about that. But we all go to movies. And when you go to a movie, if in the first 2 or 3 minutes or 5 minutes, you're hooked, you're watching that movie for a while. But how many times have you been in a movie for 20 minutes, 30 minutes, and you're like, where is this going? And
Right.
I don't want any jurors to do that. So I always try to have a good, exciting opening statement and then have my first and second witness be like the wow factor to have the jury go, oh, okay, this is going to be interesting. I'm going to tune in. And then you can get some of the boring stuff in the middle. So I think it's all important, man. We're producers, we're actors, it's theater, it's drama, and you just got to do an A+ on all of it.
Well, it's like we're directors. And the thing that's tougher being a trial lawyer is movie director only has one director.
Right.
Whereas we got another director say to the jury, our case is full of crap.
Right. No, that's right. That's right.
You
Yeah.
got two movies being shown in this courtroom at a minimum.
Yeah. And you're trying to read your audience, which you can't do because they can't get up and walk out like we can in a movie theater.
That's true. So I know everything's important in trial, but it sounds like if you were going to say what you think maybe has been most important in your experience, you'd say closing argument.
Yeah, I think so. And I'll just weave one thing into that. It's, I videotape all my depositions. And so I try to, I've got a little, I won't call it a trick, but a cross exam thing I do. And I don't consider myself the best cross examiner of experts. So I've got a Fred Flintstone way I do it. But they will always impeach themselves. I'll have those video clips of the defense. And so in my closing argument, when you're going through the facts and the law, I love to run those video clips of what I got the defense to admit and try to taint them. So, yeah.
Now, let's talk about video clips for a second since you bring them up. I think those are incredibly powerful. Sounds like you found that to be the case too.
Oh, absolutely. I mean, you remember back in the old days when you and I started out, you'd get up in your closing argument and tell the jury, well, remember when witness Smith was on the stand and said this? And if your notes don't reflect that, tell the reporter that you wanted to come in, and then you got a big long read back. It was a total different animal. And then we had videotapes, VHS, made it hard to edit, but at least we can do it. But now it is so easy. We should be videotaping all of them, and then you can just edit them as you see fit. And there's nothing better than just running a clip of an expert, especially if you impeached them. Yeah, it's just wonderful.
And technically, when you run the clip of the expert, do you just run the video clip, or do you also have the transcript transcribed below?
I've done it both ways. And sometimes the witness is hard to understand.
Right.
So I do it both ways. But then, if I'm thinking it through, we know that some people are auditory learners, some people are visual learners. And so just showing the videotape is going to get the auditory people, but maybe not the readers or the visual people. So typically both for that reason.
Okay, well, let me ask you a little more about closing. Now, when you start your trial and you got your panel of 40 in there to the courtroom, and even after you picked your jury, they don't really know you very much. And you're just getting to know them. And that's even true in the opening statement.
Right.
But I think a significant difference, and this relates to your closing argument ideas, you've by then, and you better have by then, established credibility both as a person, as a lawyer, for your case, for your client, for your witnesses, and that's got a big impact in terms of trying to persuade people at the end, doesn't it?
Oh, absolutely. I could think of my two best verdicts I would love to take credit for, but I'm going to give the credit to the defense lawyer who lost credibility. I mean, from voir dire to opening. I mean, their opening statement was like a closing argument. They're attacking my first witness. And, my belief is, you have not earned the right that early on to get your honest indignation hat on. Now, you might have been living this case for years and you might feel honest indignation, but you better start out, pretty objective and fair. I mean, you could hammer here and there depending on the facts, but yeah, credibility is key, and nothing can lose it quicker than if you go in there swinging, I believe, until you've earned the right to.
Well, I agree with you completely, and I think you're spot on. In opening statement, I agree with you. I think you have to be objective, impartial, and the jury has to have the sense you're telling them straight,
Right.
right?
Yes.
But by the time you get to the closing, you can show emotion.
Or
And that's the time to bring it all out, right?
yeah, and if you're not winning by then, it doesn't matter, that you do that. So, yeah, when it comes time for close, tee it high and let it fly and argue your case, and believe in it and show that passion and show why you're right. And you better do it by that point in time for sure.
Yeah. Well, in terms of trying your cases, and we'll get into some of the details of the trial here, but you know, have you learned any important lessons about trying a case? I mean, what would be one or two important lessons you've learned to say, hey, this is really key?
Yeah. I don't know if I have a key, but I will say a couple lessons I learned when I was, very early on. We're always taught, I believe, I don't know what they teach anymore, but when you and I were baby lawyers, you didn't want to have an expert on your jury panel that would be an expert in your case, if it's a medical doctor or things like that. So I remember thinking, well, there's exceptions to every rule. And I had a case where I had two defendants, and I knew the jury would understand why one defendant was negligent. And I thought, but the jury's not going to appreciate why the second defendant is negligent. So I left a PI attorney on my jury panel. And I thought they'll go back there. They believe in my side. They do what I do for a living. And they're going to explain to the jury why that other defendant is in the case. So I ended up winning the trial. Verdict was 11-1. And it was the lawyer who wanted to defense me. And so, I mean, I don't have a black and white hard line rule that, you don't have experts on, but I did violate the rule there, and it really did blow up on me. Now, I've had engineers on my jury when I just run out of peremptories and couldn't get them for cause.
Right.
And I've had them do fine for me. So, I don't know if that's a rule or not, but that was one big lesson. And so I typically will never have experts on my panel, at least as a bright line test initially, and then we'll see what happens after that.
Okay.
And then, I think it just goes back to the preparation. I mean, I know, we've all had those cases where we prepared really hard, but, I get caught up running the law firm and not as prepared as much as you want to be. So you're doing a lot of prep during trial. Now, I've not had that backfire on me that I'm aware of. And I've had good verdicts where I am scrambling during trial doing that, but you're up till 2 or 3 in the morning,
Yeah.
and that's 4 in the morning. That's no way to try a case. I mean, the goal is to have it ready and get to bed at a reasonable hour.
Right. You don't want to be exhausting yourself during the trial by having to work 24/7.
Yeah, yeah. So, I know better than to do that, but hey, we all don't always follow our own advice.
Well, the lesson you talked about learning as far as that person with expertise, the PI lawyer, seems to me that one of the things that happened to me, and I'm sure it happens to all of us as younger lawyers, is, for example, I think we believe naively as a young trial lawyer that we're going to be able to overcome some problems. As an example, let's say you get a potential plaintiff and that you think they've got a great case, but you can't stand them when you're interviewing them. Now, I think the mistake I made as a young lawyer is I would tend to think, oh, I can fix them up, I can clean them up. But I think I learned with time and experience that nope, that doesn't happen, right?
No, that's a great point. And we all had those cases. And I'm going to say more often than not, 90+% of the time, a bad plaintiff or a plaintiff that doesn't come across well, you're not going to fix them.
Yeah.
What I have done, and I'd be curious to see what you have done when I've had 2 or 3 family members that are going to have to testify on an issue, and I'm concerned about them doing a good job. Some, I'll bring in a jury consultant sometime and let them work with them and just kind of sit and loosen them up. I've never had that be overly effective because then they get on the witness stand. I've just not seen it work too often. Now, a few times though, when I've done that with a few family members, and you've got the one plaintiff that you think like, oh man, that's a hard nut to crack. They're going to be that way, and the other two are just all over the place, sitting there all day or for several hours with the jury consultant. Sometimes you find that one that's the hard nut to crack. They end up opening them up, and sometimes, you'll go, wow, they're going to be my star witness now. So occasionally, the silent ones that you think are just not going to open up, you can open up and be okay. But the ones that just come across poorly for all the various reasons, no, I factor that into the case. And do you really, really want to try it?
Yeah. Okay, now we're getting ready for trial, and this you can do early in the case, you can do closer to trial. How often do you get involved in having focus groups or doing mock trials, and what are the benefits you've seen from that?
Yeah, I do all the time. I won't maybe say in every single case, although probably every case going to trial, or every case I'm unsure on settlement value and strengths and weaknesses. So I do, mock trials all the time. Like, for example, I've got a case coming up right now that doesn't have the best plaintiff, but I have a decedent that lived for a couple months. And in California now we have pre-death pain and suffering.
Mm-hmm.
Like, wow, what's a jury going to do with that? I know I really can't put the error on the stand. I'm actually, thinking of letting them out of the case and just trying a pre-death pain and suffering case. And we're going around the office, and one of my partners is, it's $100,000. Jury's not going to give you money for that. And other people a few $100,000, and I'm like, I don't know. And so I did 3 focus groups before the mediation and was shocked at the 8-figure numbers that the focus groups were spitting out. Now,
Were they decedent?
yeah.
Wow.
And now I'm not taking that to the bank. It's just a
Right.
data point. I realize that, but that was very enlightening for me. So I'm digging into that further now. I'm going to do some more focus groups on that issue. Just one other little example of a focus group I did, and this was years ago, and something I didn't think of. I had a little kid who got burned, and he got burned pretty bad. And there was an argument that the parents were comparatively negligent. They were out camping, and
Mm-hmm.
so he was inside the trailer sleeping, and they're out at the campfire. I mean, you got to let your kids sleep. So I never really thought that they were comparatively negligent, but there was an argument that they were. And so I did a focus group, and I'm showing pictures of the kid out on the campsite jumping his little motorcycle. He's like 8 years old, jumping his motorcycle, and showing how he used to be active was my point. And now he can't be that active anymore, and they took that away from him. When I'm watching behind the two-way mirror, the focus group of the jurors talking, they come up with, I don't think those parents did anything wrong. They're safe people. I mean, look at their child riding that motorcycle. He's got a helmet on, gloves on, leathers on. They've got him all protected. Never dawned on me to use that to say on how careful they were. And I have a lot of examples like that from focus groups. So they're invaluable because they think of stuff that we don't.
Yeah, that's a great example. And I'm sure you've had other cases where you had some problem issue or something, and then you do focus groups, and they've given you a way to either discuss it or maybe a phrase to use. Has that happened?
Oh, that's happened for sure. They can give you a theme, they can give you phrases, they can show you some evidence that you are kind of discounting. And all of a sudden, that's maybe why you're winning the focus group. So it's invaluable. Now, I want to caution everybody, the reason I think we should always do more than one, and this happened to me when I was a baby lawyer, is I had a tough case and I did a focus group, and there was an issue that came up. And so I lost my focus group on that issue. And it was an issue that I could easily fix. Now, I didn't bother doing another focus group. I've been a lawyer for a couple of years. We didn't have a big budget. So I go try the case, and I get around that issue, but I get defensed on another issue. And I was just too young and green to appreciate, if a jury's going to defend you, they're looking for a reason to do it. So just because you fix something doesn't mean there's not another reason that they're going to defend you if it's a difficult case. So, that's a cautionary tale, I think. If you're going to do focus groups, don't do one and then just think you've got a winner and you can take it to the bank. You got to do several.
Yeah, you can't assume that you've uncovered all the issues with one
Right.
focus group.
Right, for sure. And I was young and green, and it was 30 years ago.
Okay, so now uh, before the jury panel comes in, you're going to be doing some motions in limine. Now, a lot of trial judges will complain that too many motions in limine are filed, but from your perspective on the plaintiff side, you mentioned something already. You file these kind of motions about preventing certain things from the defense in your defect cases. Do you have any other kinds of motions in limine that you found to be effective on your side of the case?
Um, I mean, yeah, the short answer is yes. So my rule of thumb on that is, uh, I want to exclude on the products cases again the stuff I've already talked about, federal motor vehicle safety
Yep.
standards to test things like that. But then I'll also, if the defense has done certain tests, sled testing, car to car crash testing, I'll do a motion to exclude that. Not that I'm going to win it, but so when they do the motion to exclude mine, the judge is just going to let it all in. So, one of my strategies is, and I think I don't think it's a secret. A lot of people probably do it, is
Yep.
I will file some motions to lose so I can win the ones that I really have to win and not look like I'm just winning everything in my favor. Now, that's not to say I file 20 or 30 motions in limine to lose 20 of them. I like to keep it under 10 if I can. You can't always, but I like to keep it 10 or less. And I will have a few in there that are just kind of throwaways.
Yeah, that makes sense. That makes good sense.
Yeah.
But there's a lot of motions that tend to be filed, especially on the defense side, where trial judges will often be saying, "Look, you're asking me to prejudge the case," but they can say that to the plaintiffs too. So you're not going to win all those motions, but that's a good strategy you've got. Now, let's say you've anticipated an issue and you don't know where the other side has spotted it. Maybe it's an evidentiary issue or something else. Um, and I've had a practice of what I've done in trials, but do you do anything? Because, the problem, if you spot an issue and you make it a motion limine, you're telling the other side about it if they don't know about it. So how do you deal with that?
Man, put on your seatbelt and say a prayer. Because, obviously, if it's really bad, you're going to want to bring it out. Just in case it comes out, you better nip it in the bud. But if it's remote enough, then you're in that dilemma of, well, I don't think they're going to find out. I don't think they'll pick up on this, and so I'm not going to bring it up. An example that comes to mind, and it's not on a piece of evidence. If it's a piece of evidence, I'm normally going to know that they're going to figure it out, even if they haven't brought it up in depo. I'm going to just bring it up because if it's something an expert did or a certain fact in a case, they're gonna stumble onto it if they haven't already. Maybe they're sandbagging me. But I tell you, one time I was in this trial in Albuquerque, New Mexico, and the morning before we not start trial, we're in trial. The morning before this witness is going to take the stand, we're having breakfast, and I'm going through, the prep with him, rehashing what we did the night before. And he says, "Hey, Brian, you know, you know, I don't know if I've ever brought this up to you before, but a long time ago, my testimony got stricken in this case." Okay. And it was like 20 years ago, 25 years ago. I mean, it was a long time ago. But this expert was a national, well-renowned expert and had testified in his expert deposition that he had never had his testimony stricken. So,
Oh,
I'm sitting here at breakfast, one, angry. Why are you telling me this now? You knew this a long time ago. You could have at least not popped it on me the morning I'm walking into court. And so I was sitting there, what do I do? And debating it about, I'm talking to the trial team now on that one, because it did seem so remote. And I wasn't aware of him being impeached over the years because I've used this guy a lot. I did not bring it up and it didn't come out. But boy, when they went up to cross-examine him, that was a nerve-wracking, hour.
yeah, you do get nervous when your witness is being crossed and you don't know what's going to happen.
Yeah, yeah, that was not a fun moment. So
Yeah, that's a tough part of the trial. I mean, as a well-prepared trial lawyer, you're always sitting there trying to keep your poker face, whether it's your client or other witnesses, and you're hoping to hell they don't screw up on the witness stand,
yeah.
but you can't control it.
No, I mean, that's kind of the fun part about trial. I think why people like us enjoy it. I mean, obviously we want to help people and help make their lives better, but the
Right.
intellectual challenge of it is a lot of fun. And that roller coaster, I've had cases where the defense in the middle of trial want to pop in a test. And I'm like, Your Honor, they can't do that in the middle of trial, yada, yada, yada. And it comes in. And I'm sitting there going, oh no, lunch break, what am I going to do? This is going to torpedo my case. And then you chew on it for a little while, and then I end up using that test in my closing argument because it helped me. So that's one of the fun things too. You never know, this bad stuff that happens during trial can end up being a blessing.
It
So
could be a blessing, and you don't
usually take
even
the
know at
blind,
first.
right? Yeah,
Yeah,
but your knee-jerk reaction, something new, is like, no, 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 danger.
exactly. So now, in your panels come in, you're starting to pick your jury in voir dire. Do you tend to give a mini opening in every case these days? And when you do give a mini opening, what's your strategy and how do you approach it?
Yeah, I do. I love many openings. I think it's a lot better than obviously reading a statement of the case.
Yeah.
Um, and and what I do is I do a mini opening, with the intent on, be having it be very vanilla. You don't go in there and try to win it. I mean, it's too extreme to say I go in there to lose it, but it's closer to wanting to lose it than win it, for me anyway. And I think a lot of people look at it that way because then you're gonna pick out your bad jurors right away. And if you give a very vanilla mini opening, one that you would never give in your regular opening, you're going to get some of those jurors that just anchor themselves to some very bad statements, and you're going to get them off for cause. Where we've all had the experience in the old days, when they do the statement of the case, nobody knows what it's about. You get a bad juror, you get to admit that they can't follow the law, and then
Right.
it's like, well, you'll follow the law, won't you, sir? And then they rehab them, and they go, yes, I will. With the mini opening, you get them to sometimes just say stuff that even a bad judge that wants to rehab them by intimidating them can't do. So I'm a big fan of mini openings.
Do
Yeah.
you talk about bad facts in your mini opening?
Yeah. I mean, I make it more about that really than the case itself. I mean, obviously you talk about your damages and stuff, but yeah, I highlight the bad facts and because I want to hear what those folks are going to have to say about it. Yeah.
Okay.
Yeah.
So now one of the things we talked about earlier is you're getting to know the jury at the beginning and you're developing this credibility and developing a relationship that becomes really important by the close. So as a plaintiff's lawyer, and you're only going to go to trial probably on cases where you've got significant injuries, you're talking about a significant award. When do you first bring up dollar numbers?
Okay. Um, Great question. I bring them up in voir dire because I want to know right out of the gate, and it's easy with the catastrophic injury case because
Yeah.
I think even bad jurors, if they see somebody in a wheelchair or someone lost their child, I mean, no one's that evil to just want to hate you. And so I bring it up, write an opening statement. Now, one thing I don't do, and there's a handful of really good lawyers that do this, they will say, for example, right in voir dire, hey, at the end of this trial, I'm going to ask you for $30 million. And they'll just come up with the actual number. I'm not that confident because if my trial goes really well, I might ask for a number bigger than that. And if it doesn't go well, I might ask for a number less than that. And you got to believe in your case. So you're probably going to stick with your number. But what I will do, things like this. If I've got a life care plan for a paralyzed client, and let's say the life care plan's $15 million,
Right.
I will do the generic voir dire. Anybody, raise hand if they think there's a maximum amount they could award. Anybody doesn't believe in awarding money for things like this. And I'll say, well, we've got a life care plan. In this case, it's $15 million. So I'm going to be asking you for $15 million to compensate my client for that. And then several million on top of that at the end of the trial. I kind of do it openly that way. Yeah.
Okay. So you bring it up early,
Yeah.
but you're using it tied to some kind of a more objective thing that one of your experts has given you.
Yeah. Yeah. And that's just like, that's probably my own insecurities because I know some lawyers that will just go out there and ask for the blanket number. But, no case, rarely anyway, goes to trial unless there's really good facts and bad facts on both sides.
Totally.
And you talk about the credibility factor and earning the jury's trust. My concern is if I got up in voir dire and said, hey, on this case, I'm going to ask for $50 million, I'm worried I may turn some off. Now, again, that's just my own insecurities. I know some lawyers that they're like, hey, I'm going to win no matter what. And they're just going to say it. But I don't want to turn anybody off. So I anchor it to like the medical specials, because that's not really in dispute.
Yeah. I don't know if it's insecurity, Brian. I know I've done a lot of plaintiffs trials, and I was always thinking about that issue as I don't want to offend the jury
Right.
with whatever the number is.
Right.
But so I want to be careful about how I approach it. And you certainly want, a number you think is fair.
Right.
And the case will go different ways, and you might feel differently at the end.
Yeah.
Okay, so in your voir dire, do you use jury consultants in every case or a lot of cases?
Yeah. In a majority of them, I do. Yes.
And do you tend to follow their recommendations most of the time, or do you also go with your own instincts as trying to pick people and use your peremptories?
Well, it's interesting. So I'm going to sound like this insecure person now because I'm going to talk about another insecurity. One reason I use them is um, just to make sure that myself and my team. Well, let me answer the question this way. Typically, I agree with the jury consultant. Usually, at the end of it, we're all in agreement. And if there's a disagreement on one or two jurors, it's not like a strong disagreement.
Right.
And so if it's not a strong disagreement, and I really respect the consultant I'm working with, and I wouldn't use them if I didn't, I may defer to them on that one. But again, 95% of the time, we all agree anyway. And that's one reason kind of why I use them, because they pick juries every week. We pick maybe one or two a year.
Right.
So since they do it all the time, I want to make sure I'm doing it right, or my radar is right. And when we're all in agreement, it just gives me it's really a security blanket.
Yep, that makes sense. So in your auto defect cases, are you looking for particular types of people as far as background or experience, either the ones that you want to keep or the ones you want to throw off?
Well, we all have the stereotypes of certain kind of jurors that are going to be good for a plaintiff or bad for a plaintiff, whether it's on liability facts or damages,
Right.
things like that. So, yeah, I mean, I definitely have my checklist of, okay, the stereotypes are there, but you can't just hang your hat on that, because I've had jurors that were the stereotypical juror, and I just fell in love with them when I'm picking. They're saying all the right stuff, and I'm like, okay, they've got 5 stars saying they're good. They've got one bad star just because they're stereotype of some category, and gone with them. So, I think a lot of those stereotypes can hold true, but you certainly don't want to hang your hat on it, because you've got to talk to the people, and you'll get a vibe typically, I think, if someone's BSing you. I mean, I
Right.
guess if someone's a total mole, they can trick you, but if you talk to them long enough, I usually feel pretty good about it.
Now, before we had a discussion before this interview, and we were talking about approaches to things, and I know you've got a spiritual look about life, and one of the things I'd like you to share, if you're willing to, is I think you've got a little different approach when you're talking to that panel who's come in, where you got 40 people and you got 12 people in the box. What's that approach?
So on this like spiritual component, just to put a little meat on that bone, if people don't know what that means, or they think it means something it doesn't. For me, what I'm talking about, and you and I have talked about this, I read like Deepak Chopra books, Wayne Dyer, The Power of Intention, books like
Right.
that. So
Right.
I do and have for years lived my life that way. So I do believe in putting out good vibes and good energy. So when I'm picking a jury and I'm sitting in there in the courtroom, I will look at them, when they're in the box. 18, you got a 6-pack, 6 out front, 12 in the box. I will look
Yep.
at them and each one of them and silently say things like, thank you for being here. I appreciate your time. I love you. I'll say things like that subconsciously, just to try to make some kind of spiritual connection. Or I'm getting goosebumps as I'm saying this right now. This is interesting. So if you believe in that stuff, then I find it helps me, because I know a lot of lawyers and even jury consultants. I'll be picking a jury and go, oh man, that guy's an AH, or that person sucks. and the jury might even pick up on you doing that in front of them.
Yeah.
And I want to balance myself to be as fair and objective as I can. And when I do that, it helps me, you know, I think put on a good front. If it's all a bunch of mumbo jumbo, who cares? It didn't hurt anything.
Well, I think that stuff does work. You and I have talked about this, and from a quantum physics standpoint, everything is really energy at the lowest level, and I think there is that energetic connection. And so, why not use tools that maybe aren't the traditional tools? And if anything can possibly help, why not?
Right. No, I agree, and that's why I do it. And it's really it's important for a couple of things. I mean, if you believe in the vibrational stuff that we're talking about in quantum physics, it's a no brainer to do it. But also, it'll help center me because we do get those jurors on there, and
Yeah,
we just have a knee jerk reaction and can't stand them. And I don't want that to subconsciously come out of me that I don't like you, or the jury goes, man, Chase doesn't like this guy. So, or
yeah.
gal. So I will even do it one just to keep me in check. If it's somebody I don't like, I'll go out of my way to, I love you. You're great. Thank you for being here. I appreciate your time subconsciously. So when I'm talking to him, hopefully I'm not frowning and scowling.
Well, thanks for sharing that. I think that's great for the audience to hear about that. So, um, when you're giving your opening statement, you've talked about this a little bit, but what's your strategy and approach there? It's definitely different from closing.
Yeah. I try to, one is, I want to make it like a movie and entertaining. So I want to start right out, and it's kind of easy in the products cases because we always run a test or multiple tests.
Yeah,
And the nice thing about that is it'll show the defect can be fixed for a few bucks. So I start right out wanting to hook them with that kind of stuff. And then I might get into some more of the more boring. Then I start out wanting to hook them on the risk versus benefit stuff and the profit over safety thing. And then I'll just kind of go beginning through end and go through the reconstruction, just sort of in chronological order.
yep,
And you definitely want to hit on the defenses. So I will have, certainly a segment on what defense contentions are. I
right,
don't want to give it a lot of weight, but you want to take the wind out of their sails. So I definitely have that, and then you definitely want to touch on damages. I save that for the end, because you don't want to offend the juries, coming out of the gate like that.
right,
And then I try to, and I had a jury consultant do this for me. I used to be one of those a little more honest indignation in my openings. Not bad, but that's just a natural instinct of mine. And I was
uh,
working with a jury consultant, I don't know, 15 years ago, and saying, hey, here's how I want to do that. This case is about the risks versus the benefits. And the jury consultant said, you're telling people how to think right out of the gate. And they may not think like you, and you may want to tone it down. And so you've got to be yourself. So if that's yourself and you're winning, do it. You can't
right.
copy anybody else. But I can tell you, it it took things back a little bit. And the first time I did that, I got a multiple 8-figure verdict. And I thought it was the worst opening statement of my life because I just wasn't pounding them. And so, yeah, a little bit more mellow, a little bit more objective, and just kind of lay it out on what you think the evidence is going to show.
Yeah, it's like you got to tell them the story, but instead of telling them what they should decide,
Yeah.
you're telling them a story so they'll come to that conclusion.
Right. And I always felt there was, this kind of this character trait about me. And I've always been a pretty credible person, and it's probably because I don't lie, cheat, or steal. And so I'm,
Yep.
an honest guy. But I've always found, whether it was in college or high school or law school, people would tend to believe me or trust me. And so I used that when I was trying cases to ram it down their throat. And I was telling the jury consultant, I'm not ramming it down their throat, man. People believe me. I'm an honest guy, so I can do that. And they're going to know I believe it, and they're going to believe it. And she's going, no, Brian, no, no, no. And so I've toned that back. Toned
Well,
it back.
and you've gotten great results doing it.
Yeah, no, it has helped tremendously. So
Yeah, sometimes we got to tone ourselves back a little bit.
yeah, no, we do. And I see some lawyers get good verdicts and come out of the gate doing that too. So I don't want to tell anybody, you know, to change their style. But if you're having problems with your style and you're doing that,
Yeah,
then maybe you should tone it down a bit.
Yeah, makes sense. So when
Yeah.
you're in your trial and you're doing your direct and cross, with cross examination, seems to me, I think of cross as kind of two types of cross.
Mhm.
The traditional closed cross, where you ask a question, trying to get a yes or no, you know the answer all the time. And then there's kind of what I call the open cross, kind of a Jerry Spence approach of I'm not asking the closed question. I'm kind of telling my story, and I don't really care what your answer is. Do you tend to use one or the other form, or do you tend to use both and you mix it up?
Yeah, both. I think you have to use both. Um, Certainly the closed cross. I mean, I think you want to do that for sure. I've never not done that. And
Yeah.
in one little trick I do is with experts, I will literally type up the question that I asked him in the deposition when I got the answer from him. And I
Ah,
will say it verbatim. And as soon as they disagree, and then we go have a sidebar, and they're like, wait a minute, Your Honor, Mr. Chase didn't impeach him. And I go, have the reporter read back the question I just asked. It's verbatim from the depo. So I will find, you know, 3 to 6 areas with experts and literally almost read the question back, although I don't want to sit there and read in front of the jury. So, I do that just to get the impeachment stuff that I know I'm going to run in closing argument. But then you also, to go to your Jerry Spence analogy, is just tell your story. Because even though the judge tells the jury questions aren't evidence, if you tell your story effectively, some of the jurors are gonna hear what your story is and they'll understand why you're going where you're going. So I think you
it
should.
can be pretty darn effective.
Oh yeah, no, someone that's really, really good at it. I mean, there's some people, that are masters at that, and Spence is one of them. But I've seen some lawyers are just great. You know, I I'm going to say I'm okay at it. I know it's important, so I do it.
Yeah.
But what I don't like about it is you're telling your story, and then you're getting this answer, and there's always a piece of me that's like, I hope the jury's not paying attention to the answer, and I hope they're paying attention to my story. To me, it's a little more daring to do it that way, but I think all good trial lawyers do it.
Well, I think it is a little more daring, but on the other hand, it kind of depends upon if you've got a compelling and believable story that holds up,
Right.
then sometimes that open close cross is very effective because whatever their answer is, it's not going to make a lot of sense. The jury's going to go, that guy's full of crap.
Right. No. Yeah. That's the prayer.
Yeah, that's a prayer. Now, what happens? Some, I don't know that experienced trial lawyers will do this, but when you're young lawyers in law school and you're taught this thing, never ask a question where you don't know the answer. Do you ever ask questions where you're not entirely sure what the answer is going to be?
Rarely, but yes. I mean, as a general rule, I like to follow that. But there are times that, and it's just kind of an instinctual thing. There
Yeah.
are, and it happened in my last trial, and I was cross-examining this witness, and I didn't know the answer, and there was a good piece of me that thought he may not know the answer either on this really complicated mathematical formula, and so I'll never forget this. I'm thinking, if he answers it, it's not going to hurt me anyway, you
Yeah.
know. And so I'm going to ask him. When I said, I go, Mr. So and so, can you get up, and go over to the butcher paper, and can you show the jury your math on that? Oh, there was like 4 lawyers at the defense table. Their jaws dropped, and I realized when I saw their jaws drop, they knew he probably wasn't going to be able to do the math. And he didn't. I mean, he didn't. He missed it by a couple of decimal points. So I won't bore you with the details.
Oh,
So
that's great.
yeah, so definitely, it's kind of an instinctual thing, and I know I've seen people do that effectively, even if they get some bad answers. I notice defense lawyers do it a lot. I don't see it
Yeah.
as plaintiff lawyers doing it, and I hate it because which teaches me to think I should maybe do it more, which is why you're probably asking this question. Because I'll sit there, and defense lawyers don't mind asking 5 questions in a row, and they're just getting burped up on by the witness. Then on the 6th question, all of a sudden they hang a left turn and it comes back to them, and they stumbled onto something. They don't mind fishing in front of the jury. I don't like to do that much, but I will do it
Yeah.
from time to time.
I think you're right. The defense lawyers will fish more, but The other way I've seen this work, and it's the exception to the general rule, is sometimes when you think about a question and an issue, and you've done your prep, so you're really well prepared, you realize I don't know the answer, but there's no good answer they can give for them.
Exactly.
It won't hurt me, whatever their answer is. And
Right.
that's, you should always ask that question
Right.
if
Right.
you can see it.
Yeah. No, and it was kind of like that math question I did. They brought in this engineer
Yeah.
and this very complicated electronic system in a car. In my head, I'm like, they didn't produce a document to show that formula in discovery. And I think this guy just might be up there being a paid mouthpiece. Yeah. So
Yeah.
that's fun stuff.
Okay, so we've put on your evidence, and I'm sure you use in graphics and all this stuff. You probably even use it in your opening statement, right, to tell the story.
Absolutely.
But
Yeah.
now you get to the closing argument. So tell us about the emotion and the compelling argument and how you're putting that together. What's your strategy in closing?
Yeah. So, it's for me, it's the most fun part of trial because you can be argumentative. So
Yeah,
obviously, it's the best part. And then I use a lot of, and I didn't invent this, I've stolen ideas from the best of the best. We all stand on each other's shoulders.
we all
So,
steal.
we know that some jurors are auditory learners, some are visual learners, some are, and I forget the word, but it's meaning they touch stuff. So I will,
Kinesthetic.
kinesthetic, thank you. I will hand things to the jury for that reason. You're going to want your PowerPoint with not a lot of words, but a word or like risk versus benefit. So I want to combine all of those things so the jury, depending on how they primarily learn, will learn. And then there's some psychological components, like when I'm getting to the law, and a lot of people do this, but a lot don't. Is I'll have when I'm putting the law up on a PowerPoint slide, the background will be like books, like law books that say law on it. So
Ah,
subconsciously, this is the law. When I get into my section, and I took this from Brian Panish, and he might have taken it from somebody else for the trial techie. But when I get to the defense contentions, that's a black slide, and in red, blood red, defense contentions. Yeah. So a lot of just like psychological things
right.
like, and then one thing I do in my closes, because I think my cases are so complicated that I think it just helps organize it. So in the old days when you and I were starting out, we'd give our closing argument, then we'd go get a paper verdict form and put it on the Elmo, and then we'd answer the questions for them. So what I do now is I'll start out for 5 or 10 minutes, and I'll do my, I have a Margaret Mead quote I do, and I want to empower the jury and the conscience of the community and all of those types of things, and talk in a 5 minutes kind of discuss some of the evidence why we should win. But then when I get into my real part of the opening, I've got a PowerPoint slide that shows that it's the verdict form, and I'll say, ladies and gentlemen, you're going to have this in the back of the room.
Right.
Then I'll hit the button, and question number one will come up. Is the product effective? And then I'll go into all that defect evidence, and then I'll come back and say, have the box check, yes, it is. And I suggest, I don't tell them, I suggest. I would have told them 15 years ago. Now I'll just say, I suggest the evidence supports this, that you ought to find it was defective. And I go through the whole verdict form that way. And it might sound kind of boring, but there's so much evidence in between just showing that question. I think it helps walk the jury through how they're going to process it in the jury room, because I hate it. And we've all had this experience, I'm sure you have too,
Yeah.
where all of a sudden, you'll get a jury question on, what does substantial factor mean? And then you end up learning later on, they'll come back and go, can we have a definition of negligence? And I'm like, oh man, they're all over the map. And I want them to answer it the way I think they should answer it as well. So I use some, psychological stuff. This is the law, defense contentions, the black hat, my impeachment videos, and walk them through the verdict form.
But I think you do have to walk them through the verdict form, and you've got to explain why they should answer the questions the way you're suggesting. And
Yeah.
you really gotta do that. That's critical.
Yeah.
So
Go ahead.
I tell you, Brian, this has been a great conversation. We're getting near the end of our time, and one of the things I wanted to let me ask you this first, and then I'll go to some final questions.
Sure.
Every time we have a trial, whether it's a couple of days or a couple of weeks or longer, there's always going to be this adrenaline crash afterwards where you've been working so hard for so long and the body just goes, boom, I got to recharge. What have you found to be an effective way to get back and recharge and give yourself a break after your trial?
Yeah, sleep. No,
Sleep.
what is funny is, the last day of trial, after I have given, the last day of trial, if it's on a Friday, let's just say, I have found I will routinely sleep 14, 15 hours. And
Yeah.
I never do that. Maybe I could do it when I was a kid, but which just shows you how crashed you are or how burnt out your body is. It just needs that much sleep. But really after that, um, for me, trials are just so intense. After I get that good night of sleep, I'm pretty good right after that. Win, lose or draw. Uh, Trials are so stressful. It's nice to be out of them. I'm not one of those guys. I mean, I love trying cases, and you've got your highs, and
Yeah.
your lows. But my analogy has always been when I'm in trial, I'm like on the bottom of the ocean, and it's just dark and gray and gloomy. Now I can see what I'm doing, but everything is just in slow motion, and there's no sun, there's no cloud. I'm just down there. So when I get out of trial, it's like I've reemerged out of the ocean and there's a beautiful blue sky and there's a bright orange sun. And that's enough just to get me fired up that I'm out of trial. I'm
Oh,
glad,
yeah.
I'm glad I'm out of it. So one good night of sleep, or maybe, a few good nights of sleep, but I recharge pretty quickly.
You do recharge quickly. I mean, I don't know that I've slept 15 hours, but usually seems to be you need to get a few nights of good sleep and you're starting to feel pretty normal.
Yeah, I know a lot of people that sometimes literally I'll talk to them, even people in my office, take them a couple weeks.
Yeah.
They just can't get it out of their head for a couple weeks. I'm really pretty good at it. When it's done, it's done. I'm not at the bottom of the ocean anymore. And I'm going to go enjoy my life with family and friends for a few days.
Yeah, I'm good about getting it out of my head. It's just letting the body get the
Yeah,
rest it needs. Well,
yeah,
that's great. Well, let me ask you this as we get here to the close. Is there any piece of advice that you either were given as a young lawyer or that you would give to young lawyers now who want to become good trial lawyers? What's something you could share with them to say, this has really helped me?
yeah. So advice I got when I was younger, and I would still give it to this day, is if you want to be a trial lawyer, you have to try cases. And until you try cases, you can't even take a good deposition. As soon as you do your first trial and you're reading your lousy depositions that you can't cross-examine anybody on. So you've got to get in court. So I know what I did early on, and I know a lot of the really good trial lawyers now that have been doing it a long time. They just started out trying cases. So and they don't have to be complicated. I'd get a file on a Friday. We did last minute trials. Someone gives me a
Yeah.
file on Friday, I go try it on Monday, rear ender, soft tissue case. But you really just got to get out there and try cases. One, to develop your skill. And then two, to be a successful plaintiff's lawyer, you're going to settle a lot of cases too, because it's going to be in your client's best interest to settle cases. And you can't get good settlement value until the insurance companies or the defendants know you're going to try cases, even if you don't win them all. If they just know you're going to trial and you're not going to roll over and settle a case for 25 cents on the dollar, that's important too. So I think kind of twofold: go try cases, ask for last minute trials. There's a lot of law firms that will refer those cases out to you. So try your cases, and then that will also help you as you develop your career, because the insurance companies will know, oh, you're a real trial lawyer. You're not a settlement lawyer.
No, you're absolutely right. At the insurance company, and I started out as a defense lawyer, but went to doing the plaintiff side. If you only settle cases, they know it, and they're not going to give you top dollar. And
Absolutely.
even if you go to trial, you got to be willing to go to trial and lose, and you're going to lose some cases. But
Yeah.
you're going to get better settlements because they know you're prepared, you're dangerous, you're going to do the job right, and they have the greatest risk. That's how you get the best result for your client. So I think your advice is spot on.
Yeah. And something you said there is so important. You can't be afraid to lose. And it's very natural for us to go try certain cases to have a little bit of fear about it if it's an uphill battle. But I know some lawyers that are just so afraid to lose, they don't try any cases. And you just got to put that fear out of you and just march ahead.
Yeah, can't be afraid to lose. And I remember trying a case and I lost. And you hate it when you lose. You're so invested in it. You only took it because you believe in it so much. You work your ass off. But the irony that it turned out is that lawyer, who's one of the top defense lawyers in town, he totally treated me differently after that.
Oh,
And that loss was a game changer as far as future results for my clients.
oh, I've got a similar story, and I won't name names, but same thing. I was a younger lawyer and getting really jacked around on a case that I probably should have lost. Ended up not losing it, and then this defense lawyer who's got their own big defense firm now offered me a job after trial. You know, after they got me jacked around, and I politely declined. If I work for you and I got to treat lawyers the way you were treating me, I don't want to ever work for you. But thank you for the kind words.
Well, that's great, Brian. It has been a pleasure to talk with you, and you've given such great information that's going to be helpful to people. Thank you so much for being a guest today.
Oh, Monty, my pleasure, and thanks again for having me on here. I know when you invited me to do this, I was really excited. So thank you for what you do, getting great lawyers on your podcast to talk about a lot of the same things, but say it totally differently because we all learn differently too when we listen to these things. So good job on your end. Thank you.
Well, thank you very much.
Mhm.